if I may show this picture, it's me and my friend Rose McGowan.
And Your Honor. Have you ever been accused of drugging and raping anyone?
I have a sidebar, Your Honor.
Say again?
I want to object, and I don't know how.
Okay, sidebar.
They're thriving, and one of them was always a loser. For me, accused is by a state prosecutor of a crime. I mean, these are crimes you're talking about, and I have never been accused by any prosecutor.
It's still up. That tweet is still up. You've never taken it down, right?
Oh, I don't do the thing where I put up something and then take it down like your client did with a reporter he was associated with who's sitting in the back of the room.
I know you keep talking about that. I'm done talking about, I get it. It's not the same event. I got it.
I wasn't investigating them. That was the impression that they gave me, that they were benefactors of settlements in the past.
If you're saying all of that is incorrect, why would they not be able to corroborate that?
Because, Your Honor, they're doing it based on hearsay and it's bad character propensity.
It's not hearsay. They want to bring the person and put them on the stand. That's in-court testimony. That's not hearsay.
Who put them up to this? I have lots of questions. There are grave concerns.
Your case in chief. You'll have that opportunity.
Do you intend to release the name of whoever's been identified as TS? Your pause speaks volumes. You are ordered not to disclose it without further order of the court. Okay?
Let's answer the question, Mr. Frevola.
My name is Mr. Basabe.
Is this talking about the underwear in the pool episode?
Any person that they may have here, which I'm assuming is my opponent's, my opposition, the guy right there that's part of the Democrat, whatever, is there. It's all hearsay anyway.
Is this the first time that anyone has made allegations that you sexually harassed them?
There's a lot of gossip. I'll chalk it up to gossip.
All right, I'll take that as a no.
Please don't answer for me.
I'm not allowing TS. No, we're too far afield on that. Why do we keep talking about TS when the court says no?
Who is the witness?
That whoever TS is, they're about to call this person to the stand. We're about to find out.
Which one? Which one was the loser?
Well, I didn't single one out yet, but it seems one just offered himself up.
We're going to handle this later. We're going to move on. I got jurors in the box. This is much more in detail than something. Let's bring in the witness.
Is the person who's coming in going to be only identifying themselves as TS?
At this point, yes.
I don't know if you can answer this, but will you state your full name?
No. No. I've already ruled on that.
Would you like me to explain my politics?
Again, he gets to cross himself, so to speak.
I mean, there's grave concern. Concern is my first response to this.
Would that be Mr. Nick Frevola?
Yes.
He's a loser.
In my opinion, yes.
All right, with that, plaintiff, call your next witness.
Oh, Fabian Basabe.
All right, Mr. Basabe, come on up. And again, you were previously placed under oath, but just like I did with the others, we'll swear you in again. Do you swear or affirm the testimony you give in the case now and hearing should be the truth, the whole truth, and nothing but the truth? All right, you may be seated. With that, plaintiff, you may proceed.
Please state your name for the record.
My name is Fabian Basabe.
You were born in New York City, correct?
Yes.
You live in Miami, correct?
Miami Beach, yes.
You're a big city guy, right?
I like to think that they're small town at heart.
You're a socialite as well, correct?
I don't describe myself that way.
Well, weren't you on a television program called Socialites of New York?
I was not.
Okay. You were actually on a show referring to the rich kids, cattle drive, something like that, with your friend Paris Hilton and Kourtney Kardashian, correct?
You're inaccurate of the cast of characters.
You were on reality shows, correct?
So
Will you please tell the jury the name of those reality shows?
This one was Cattle Drive. Paris was not on that one. And do you want me to list others?
Sure.
It's been a while. I did an episode of $1 Million Listing. I've done Simple Life to Social Life. I've done Top This Party. I've done, I'm in some documentary about me.
You just wink at the jury?
No, I didn't.
Oh, my mistake.
And there is, I don't know that it's relevant today or that you're able to do that today, but after there's a IMDb page you can go to. I don't remember. These are a really long time ago.
That's okay. You are married
Yes.
to a woman.
Yes.
May I approach the witness to show
Right.
an exhibit?
Yes.
What is that, Mark? Minus what?
Sure.
Any objection to plaintiff's exhibit 2? All right, without objection.
May I publish?
Give me.
Good looking one on the right.
Okay. Who's the name of this one?
Good looking one on the left. His name is Renato.
And he lives with you, correct?
I don't answer for people's residency. Is that allowed? Can't state his state of mind of where he lives.
All right, is there a legal objection to the question?
Assuming that I know where he establishes his which home he establishes his residency.
Is he your boyfriend?
I believe in those labels.
Yes. You're a member of the House of Representatives, aren't you?
Yes.
Right. There are 120 members of the House of Representatives in the state of Florida, and you are one of 120, correct?
Re-elected.
Congratulations. You're up for election now, aren't you?
Yes,
You represent Miami, correct? A district in Miami.
Excuse me?
You represent a district in Miami.
Yes.
And I want to say it's 109 or 106. Could you tell me?
It's District 106.
106. Thank you, sir. And you make laws for the state of Florida, don't you?
I vote on them, yes.
Don't you help make them as well?
Yes.
You also hire and fire people within your office, is that correct?
Do not.
Okay. You supervised Mr. Frevola and Mr. Cutbirth, correct?
I'm not exactly sure of the technical role that I play as they work for the House and they're assigned to my office. I don't know the technical terms of how they are in there, but they did work in my office and they were in charge of doing things that represented my office.
Okay. Well, in some of your testimony earlier when you were cross-examining, you used the word to supervise. You supervise them, correct?
I don't know that that's my responsibility because they respond to the supervisor of them would be the Speaker of the House and Human Resources.
I'm going to remind you, and the jury is free to, the judge will instruct you your own memories, but as I recall, what you testified was that you don't work for me, but I was your supervisor.
It may have been inferring to their impression, but sure, I don't know where you're going with this.
Did you supervise them? Did you have the ability to tell them what to do, what you needed them to do, and make sure that they were doing it properly?
So it's my understanding that they get intense training on what their responsibilities are. And their role is to complete the tasks that are in the work videos that they're training. And they're supposed to manage my day-to-day.
So is it your position here that you did not have any supervisory authority over them?
I don't know that officially I had that. I'm sure that I could recommend if they're doing a good job or not.
So when you stood up here earlier and you said, I just supervised you, that was a misstatement?
I'd have to remind me of the context, please, because I don't want to make a mistake for you. I don't know where you're going with this.
You were cross-examining Mr. Frevola.
I'm sorry, you do understand how much difficulty I had staying on track. I don't remember the exact statement that was made. If you'd like the stenographer to read it back,
I'll rely.
It's full context.
All right, hold on.
I'm happy with that.
Stop, both of you. Again, question answer is the same we've been doing. Question answer, legal objection. Let each other finish. All right, next question.
I'll rely on the jury's memory.
May I grab my pen, Your Honor?
I'm going to let the witness step down and grab a pen, and if he wants, because obviously he's representing himself, he wants to take notes. That's fine. Yes, sir. That's fine. And the witness is returning to the witness stand.
You're actually from me. This way. And if you would like, sir.
Thank you.
Give me a second. Remind the court. Oh, yep, got it. Yeah, you may.
Now, here on your copy, and I apologize, ladies and gentlemen, when we have this second. So I am doing just with Ladies and gentlemen, are you able to read this bottom part here? Now, it says right there, and the tweet you did, that you're speaking of Mr. Frevola, is that correct?
Give me a moment. I'm going to go through the entire tweet.
I'm only asking about this tiny part here.
Which tiny part?
Sorry, right there.
Oh, no, you're talking about the small print that's signed by Michael Matamor? Okay. So then I won't read my tweet. I'll go to the attachment to the tweet. Okay.
That is Mr. Frevola right there, correct?
This specific excerpt was not written by me.
It is part of your tweet, sir.
An attachment, yes, it's
Yes, that you attached. Okay.
I'm just stating that I didn't write this excerpt. It was just, this was included in my tweet.
Perfect. Thank
Okay,
you.
perfect.
Yes, we're on the same page. You identify Mr. Frevola.
I don't believe that a Mr. or a Mrs. is identified there. I just see Frevola.
All right. Then you identify the name Frevola.
I don't identify it. A gentleman by the name of Michael Matamor identifies it, and I had attached this to my tweet.
All right, you don't deny you attached it to the tweet.
Correct.
You do not deny that the name is Frevola.
Correct.
For me, this false accusation that the past few months went beyond great monetary cost and deprived and wasted time of all involved. For me, it ascended directly to the top of the mountain of disappointment I already felt towards the generally lazy, entitled, scrupulous, self-involved, ungrateful, lying scum who would almost continuously and falsely trash or diminutize the reputation of those around him. Many he also spoke of as friends or people who liked him, regardless of the potentially severe consequences and clearly for personal gain. You wrote that, right?
Are you asking me if I specifically wrote that paragraph, or are you reading it in the proper context?
Did you write this or not?
I wrote the entire tweet to have a significance in its entirety.
Okay, great.
I'm just distinguishing.
So you wrote it.
Again, if I can give my complete answer, I understand that you'd like to manage my answer, but I'm going to give you a complete answer. The writing here is to be taken all together in context. I'm not the Miami Herald where I choose a line that I can throw at somebody.
You're non-responsive. The comment.
Abstained. Did you write that paragraph, sir?
I wrote that paragraph within.
Okay, next question.
All right, this paragraph. I'm going to ask, did you write this paragraph? One belongs to a special kind of hell that they enter the homes of those you plan to harm, play basketball with their child, eat their food, and allow them to treat you like family, and literally, more than often, sleep on the job because you were out so late or never slept the evening before. Did you write that paragraph?
I'm giving the same answer as before, so we don't go through the entire things. In its entirety of context, that paragraph was written to me, meant and intended for the entirety of the context of the tweet.
Non-responsive, Aaron.
Sustained. Did you write that paragraph?
Yes, Your Honor, and I
Next question.
The conning, scheming mother and son duo appear to be making suing a profession. They have a reported history of lawsuits against anyone who they think can or will pay. This revolting record speaks for itself. Did you write that paragraph?
I did write that paragraph, and I'll remind you, this is my opinion.
What record?
Am I allowed to answer that?
Yeah. What is the record that speaks for itself? Let me stop you before we have to go and do another sidebar. Can you name one single lawsuit that you had proof about before you wrote that?
So you just changed it from record to lawsuit. The word here.
Lawsuit. Oh, here. You wrote lawsuit.
Okay, so lawsuit.
Okay. Can you name one?
Am I allowed to?
Well, for this claim that you are the defendant in, can you name one? At the time that you wrote this, one.
I can, because I was told by Nick Frevola about one. Am I allowed to answer that? I don't want to say something that I'm not supposed to say. Would you like me to answer
Case number?
I wouldn't have the case number. I have it on best authority from your plaintiff that his mother was involved in a lawsuit and got a settlement from the police.
Did you do a single thing to Google search, send out an aide, call your family lawyer, anything to confirm that before you wrote this?
It was confirmed by my aide.
By your aide. That's your testimony.
It's confirmed by Nick Frevola.
He has not testified to that.
Because we weren't allowed to ask about that. That's why I'm asking. If you're not allowed to ask about it, why are you asking about it? He specifically told me his mother got a huge settlement.
Gentlemen, I'm going to have you return to the jury. Sir, stop speaking. When the court starts, that's it. Both of you. Ladies and gentlemen, I have you return to the jury deliberation room for a moment.
Sorry.
All right, the jury is part of the courtroom. Be seated. All right, what we're not going to do is argue about rulings this court made outside the presence of the jury. We can talk about it now outside the presence of the jury. The questions, as I've heard them thus far, were in line with this court's ruling that the defense could talk about claims, suits, or settlements that predate the allegations of defamation in this case. So what do we need to talk about so that we don't run astray of the court's order here? But to say you weren't allowed to ask about that, I don't know that that's legally or factually accurate. You were allowed to ask about lawsuits, claims, let me make sure I have the right, or settlements that predated the allegation of defamation in this case. So what do we need to talk about regarding that, Mr. Frevola? Well, I mean, excuse me, Mr. Basabe.
So I did understand the before part, and I was going to ask that in my case in chief.
Okay.
There's a case. I was told by Frevola, my aide, that his mother had a lawsuit, and they settled on it, and they supposedly made up big, and that's what that afforded them some extra luxuries of their life or whatever they do with it.
All right.
And I was also told by Miss Frevola when she invited me to her fancy camper van that she had gotten that off of a police settlement.
All right, Ms. Viker.
Yeah. Your Honor, what's going to come out in testimony? The reason so the court will be aware, we're taking things a little bit out of order, is because we have people that actually have some time constraints. So there was what I believe the testimony will show is that Mrs. Frevola had a work-related injury, and she went through the grievance process. And so that it's a grievance process. There was no lawsuit ever.
Well, again, I haven't seen any problems with the questions as asked thus far. So I don't, as for objections, we're not to be talking about trial rulings as to admissibility. These are within. So I think counsel's been asking the questions in line with the court's rulings. If you'll answer the question that is asked, if you have a legal objection to it, object to it, and I'll make a ruling. But otherwise, the legal question as asked, if you'll answer the question as it is asked, we don't run into these problems. It's when we go outside of where the question is as asked that we end up in problems. With that, I'm going to allow the question as asked. We'll bring them back in here and we'll proceed and understand where we're going. All right.
Thank you, Adam.
Let's bring them back in. Ms. Viker, you may proceed.
Yes. Mr. Basabe, did you do anything to verify whether or not the Frevolas had ever been in a lawsuit prior to writing what you wrote?
I took them for their word. Nick Frevola and Jeanette Frevola both told me about settlement that they had received, or that she had received in prior times.
Now, you use the word lawsuit, do you not?
That is in there, yes.
Did you do anything to determine if there was a lawsuit?
It was the word that Nick Frevola used when he described to me what it was about.
That's your testimony for the jury. Okay, and is your testimony also that you did nothing else to verify before you wrote that? Is that a fair statement?
Besides confirming from the sources directly that they had received a settlement or something in the past, I wasn't investigating them. That was the impression that they gave me, that they were benefactors of settlements in the past, or a settlement in the past.
So no, after Mr. Frevola left your position, after the report had been made, and prior to making this tweet, you did not independently try to see if there had been a lawsuit, correct?
I based my opinion on the information I had at hand from your clients.
Responsive, Your Honor.
Sustained.
Please answer the question, Mr. Frevola.
My name is Mr. Basabe.
I'm so sorry. Thank you. Yes, sorry. Mr. Basabe, please answer the question.
Can you repeat the question?
Yes. Between the time Mr. Frevola left working under your, whatever you want to call it, supervision, and the time that you made this tweet alleging a lawsuit, you make any independent review to determine if, in fact, either Frevola was involved in a lawsuit?
Did not make any additional effort to find out whether they were telling me the truth or not.
This revolting record speaks for itself. What's the record?
The record is what was attached.
Okay, and that's Mr. Mattamore?
So this record contains, am I allowed to say the word investigate? Am I allowed to say what?
Well, I say no.
No.
They're referring to this.
Please show me where the paragraph is. Which paragraph is it?
I'm referring to the one down here.
No. Where you're saying I'm talking about the lawsuit records is this last. It's Connie and Skinny Mother and Son duo appear to be making impression. They reported lawsuits. This revolting record speaks for itself. Yes, got it.
is this blur here?
So it's accumulation of things. It's the record of my memory of the events that occurred that helped me form my opinion, from the investigation referenced in the first paragraph to the conclusions referenced in the last paragraph. Investigations regarding allegations regarding me concluded in my favor, and then at the end, you have Michael Latimer, I believe he's the investigator, saying, with respect to specific allegation by Frevola that he was slapped in the face by Basabe, conflicts in factual accounts provided by participants and lack of corroborating witnesses. Findings inconclusive.
Now, you were offended that you had been accused, correct? You were offended by what Mr. Frevola, Mr. Cuthbert had said about you, correct?
Are you objection? You're stating my speculation of my first reactions. First, I was very concerned.
All right, hold on. The objection is overruled. You may answer the question.
I was concerned.
You called them ungrateful, lying scum, lazy, entitled, unscrupulous, self-involved. That sounds like you were offended. Were you offended?
I'm still offended, but my state of mind on that day, that got to my opinion, I believe I'm entitled to my opinion.
It's still up, right?
Legally as well.
It's still up. That tweet is still up. You've never taken it down, right?
Oh, I don't do the thing where I put up something and then take it down like your client did with a reporter he was associated with who's sitting in the back of the room.
Responsive here.
I just said,
Is it still up?
So I will double check, but I believe it should be. Should be.
All right. So you were offended by these accusations. Have you ever been accused of drugging and raping anyone?
I have a sidebar, Your Honor.
Say again?
I want to object and I don't know how.
Okay. Sidebar. All right, the objection is sustained. The jury will disregard the last question. No, I'm going to send them to lunch. All right, ladies and gentlemen, we're going to take our lunch break for today. If you'll leave those notepads face down, it is 11:45. We'll come back at 1 p.m. All right, the jury is part of the courtroom. Everyone may be seated. All right, I think Ms. Viker gets to go first. She wanted to go back to sidebar, and then by all means, you can ask a question. All right, what are we here to talk about?
Right. So am I going to be able to ask him if he had been accused of drugging and raping?
No, not as based off the discussions we had at sidebar and the mode in which you were going to ask those questions. No.
Your Honor, we have a rebuttal witness that is ready to come and testify that did happen. So that is what, and he's not wrong. It's not that I'm trying to trick him. It's that in this case, he was accused of far less, and he was hung out for credibility. He was hung out for years, and yet he was accused in the past. He is so.
Well, what I don't understand and why I was looking for the stream here is the question as phrased. I'm not going to let. As far as you've been accused of worse, you denied it. You didn't make these allegations, something like that. That I would have allowed, but the fact that the nature of this, having somebody come back in, etc. Again, we're down to the same pretrial ruling I made regarding the sideshow. Mr. Basabe had properly shown that was inappropriate character evidence based on this temporal distance from the accusation. And I've seen nothing that resurrects that and makes it okay at this point.
Right. Your Honor, could I proffer a series of questions differently, perhaps?
Say again?
Could I perhaps proffer a different series of questions?
Of this witness?
In regards to this other person and this allegation?
By all means, and I'll let Mr. Basabe stay at council table. But as
Would you like me to return?
and you can return to council table as well. I'll allow the parties to remain seated during this, and I'll allow the proffer outside the presence of the jury regarding the question. But you may proceed with your voir dire outside the presence of the jury. Go ahead.
All right. Mr. Basabe, you've heard accusations that you offered drugs to Mr. Daniel Diaz. You admit or deny?
I object to the question.
Okay, basis.
Seems facts not in evidence.
What do you mean facts not in evidence? I agree. It's up to them to decide whether or not. But didn't we have testimony that there was inhalants offered? Again, that may be inaccurate, and ultimately it's for this jury to decide. But there was testimony in this court that there were inhalants offered. Now that may be inaccurate. It may be, that'll be up for this jury to decide. But how is that facts not in evidence? That's a fact that's in evidence. Now what they make of that is up to them.
Your Honor, they're trying to circumvent.
You can remain seated. I appreciate it.
They're trying to circumvent the judge's prior rulings on the TS. Improper propensity has nothing to do with some over-the-counter, whatever they're talking about, inhalants that they're trying to reference. I don't have illegal drugs.
Okay, well, why isn't that the answer? No, I didn't do that. All right.
There's a danger of unfair prejudice outweighed by probative value, and this is a bad character propensity evidence.
All right. As to the 404 and 403 arguments, Ms. Viker?
No, the court had discussed the remoteness as it pertains to this particular witness. And what we are, if it was to come in, what we would argue is that this is just not only a pattern and a practice, this is a decades-long series of events that has culminated in the exact same behavior that has been described here. So my next question, with Mr. Diaz is, or after.
Mr. Diaz doesn't have the temporal problem that.
No, Mr. TS does.
Oh, TS.
Yes.
Okay. Tango Sierra, got it.
Yes. And that what the testimony would be is almost identical to what has been described here, Mr. Cutler, and the behaviors observed by Mr. Frevola. And those, in the instances with these other, even though it's made the media, there has not been any kind of defamation of the accusers prior, like there has been here. And these were far more severe. So it goes to show that the likelihood, then this is a he said issue. That's what this trial is all about. But this witness, Mr. Diaz, the testimony that we're going to bring in, what both of my clients have testified to are going to be corroborated by this witness it is shocking, Your Honor, the similarities. If you'd like, I could offer.
I guess before we bring in the witness for a proffer, we may have to do that. But is this talking about the underwear in the pool episode?
This is underwear in the pool. This is hand on the thigh.
Well, isn't that inextricably intertwined with what's going on? I mean, we've already heard about that in this case. So
it is, sir. And Mr. Basabe has adamantly denied and is offended that someone would accuse that, which is why an unrelated party, he's even said that their testimony has been orchestrated, that this is a conspiracy against him. We have an independent person who has flown in, a witness who chooses to be here on their own time, their own dime, not at all associated, that shows this is a credibility issue, and it supports these young men's credibility.
All right, Mr. Basabe.
Your Honor, this runs the risk of the jury reaching a verdict that's relying on testimony and evidence that's not alleged in the amended complaint. And also plaintiffs did not allege that I drugged and raped any person that they may have here, which I'm assuming is my opponent's, my opposition, the guy right there that's part of the Democrat, whatever, is there. It's all hearsay anyway.
Wait, I missed that last. What was that last part? What?
Yes, may I understand who they're? I'm going to stick with arguing their points first, Your Honor. But this runs the risk of jury reaching a verdict relying on testimony and evidence that's not alleged in the amended complaint, and that the plaintiffs don't allege that I drugged and raped them.
Okay, but you have in your cross put Mr. Frevola's credibility at issue, right? I mean that you put Mr. Frevola's credibility at issue, correct? I mean, you don't want them to believe him. I mean, that's right.
And I believe he put his own credibility at risk.
Okay, but you have questioned the truthfulness and the veracity of the testimony he's given in court, correct?
I believe I've allowed him to walk into the fact that he's not been honest.
Okay, well, again, you challenged his credibility here in the court, which again is a normal practice of defendants to do, either pro se or through their counsel, right?
Your Honor, this is irrelevant to the allegations against him.
Well, that's where I'm going with this is, why is that not relevant to the specific talk about going to Miami, drinking, laughing together, underwear in the pool? It was between 12 and 1 a.m. They were offered something else. There's this inhalant, grabbing Danny, trying to kiss. Let's go to the room. Hey, don't get out of the pool. Don't do it from Kirkland. I mean, this is all part of the case in chief. So why would they, if you're saying all of that is incorrect, why would they not be able to corroborate that?
Because, Your Honor, they're doing it based on hearsay and it's bad character propensity.
It's not hearsay. They want to bring the person and put them on the stand. That's in-court testimony. That's not hearsay. Now, there may be hearsay within it, subject to objection, understood about what somebody else might have said, got it. But they want to put the witness on the witness stand. That's not hearsay.
Your Honor, the probative value is far outweighed by the danger and unfair prejudice, and they're circumventing the judge's prior ruling to your motion in limine.
No, that one, as to TS, I'm with you. That's why I've sustained the objection as to TS. But as to Mr. Diaz, my recollection, as I said, that was this is a percipient witness. This was something we talked about, witnesses and the like. And I said, well, wait, this is a percipient witnesses to actions in this case. I mean, if I have that wrong, somebody let me know. But I believe that one came up, and I said, oh, so you're saying a percipient witness in this case. And then we spent a lot of time on TS talking about the temporal, and I didn't talk about the distance proximity. One of them was alleged to be in California, and one of them alleged to be here. But this is the same time, place where one of the plaintiffs was located, simultaneous with Mr. Diaz.
Your Honor, again, this is not about Mr. Diaz. This is about the TS, California person that's unidentified to date, that was not admitted. And that,
Wait, you said this is not about Mr. Diaz. This is what?
This is about TS, the fictitious.
I've already ruled on TS. Are we, Ms. Fiker, were you talking about TS?
His testimony that corroborates an identical story to what is described.
No, I'm not letting that in. That's no different. I'm not. That ruling that one's staying out. I thought we were talking about Danny Diaz.
Your Honor, and I understood that it would be open to rebuttal if he had denied being made allegations other than this one. And that's where I was going with my questioning, had he been previously accused.
Your Honor, I objected to that.
Yeah, I'm not allowing TS. No, we're too far afield on that.
Sorry?
I'm not allowing the testimony of TS regarding allegations from 20-something years ago. I'm not allowing it.
Thank you, Your Honor.
All right, what else do we need to talk about?
So, Your Honor, if they have somebody in the courtroom who is supposed to be testifying after they confirmed a list of who will be testifying, they've been sitting in here listening to things after you invoked the sequester.
Well, who are we talking about? This is, what are we talking?
Right there.
I don't know what you're talking about. Somebody will have to enlighten me.
Who is your? I object to any witness that you have that was not agreed upon, disclosed, that I haven't had opportunity to depose.
Okay, well, we've already had that discussion. There's no motion to reconsider that ruling. All right.
Would like an instruction, just to make sure that we're clear that under the Mercy's law, if Mr. Basabe does get the name of the initials TS, that he not be allowed to publicize that or hunt him down or bother this man.
Why would that? Would you be saying that name? Why is that? I've said no on that. Why do we keep talking about TS when the court says no? Other than
make sure we understand that name is still protected and cannot be disclosed. That's it.
Do you intend to disclose that name in any way, shape, or form, Mr. Basabe?
Your Honor, I have no intentions of revisiting any of this nonsense. But however, if somebody is...
It's not my question. Please answer my question. Do you intend to release the name of whoever's been identified as TS? Your pause speaks volumes. You are ordered not to disclose it without further order of the court. Okay? All right. Thank you. We'll be in lunch until 1.
Please be.
We know the man, though. Seemed pretty chummy. Not allowed to lie in court either.
Oh, that's a really bad idea, but I'll do it. Us and the courtroom, he was filming.
Who was he?
He was. I was looking right at him. Who? Shit, man, poo-poo face, doo-doo head.
He was filming us?
I reckon. He's a word.
Legally.
Yeah, he may not know that he's not allowed to do that. Telling you what, this is the weirdest case I've ever been a part of.
Find out what went on down there this morning?
No, I didn't. I'll find out in a minute.
Oh, is everything all right? What happened in my head? You remember that song from the 90s, Date Rape? There was a song in the 80s called Date Rape by, I believe, Sublime. She didn't want to. It's just an old song from the 90s. So listen to it now. It's in my head. Can't imagine why.
All rise. Court is in session. The Judge J.T. Marsh presides.
Everyone may be seated. All right, we're back in Frevola versus Basabe, 2023 CA 1820. The jury is absent. With that, what matters do we need to take up before we bring them in? My understanding is they've been brought into the deliberation room and getting ready to hear testimony.
Plaintiff has 3 issues to address.
Okay.
The first, well, I'll just tell you what they are. The first issue is in terms of TS, is my proffer enough, or does the witness need to come in to preserve the record? Is the first.
Well, I'm not about to advise you of how to preserve the record for appellate review. I'm not gonna go there. If you need to bring the witness in for brief voir dire, and I mean brief, folks, we're not having a 3-day hearing on this just to get to the end of that.
Yes, sir.
So if that's what you need to do, that's what you need to do. But
yes. The second issue is that I'm not 100%. I do believe that the name of the protected party was shared with Mr. Basabe. I can't remember for sure. I have not asked him if he has disclosed that name, and I wondered if we could get a proffer. If he has, if so, who, and could we also extend the order that name not be shared?
Well, I ordered before the lunch break him not to disclose it without further order to the court. What's the necessity of needing to know whether prior to that he did? If he did it after that, that's a separate contempt issue. But is there any reason we need to inquire of that?
Just want to try to make sure that we protect this man's identity.
Well, I understand that, but I'm not asking whether he has before or subsequent. But Mr. Basabe, any reason the court needs to inquire into prior disclosure of that name?
To the best of my knowledge, I to this day don't know that name.
Okay. There you go. Well, that makes it real easy. If you don't know that name, don't disclose it. Won't be a hard order to follow. That's
Your Honor.
sounds good.
Can I ask a quick follow-up question?
Well,
There was something that was in the media. Was any of that his real initials or real name?
I'm not following the media. I know there's media stuff on that. I don't know. I'm not addressing media stuff unless it's properly brought before this court. So I have no idea. All right. What's your next issue, Ms. Funk?
Last one, just handed it to Mr. Basabe, and there is one more case, and it's not to anyway.
The court, I printed my own copy if you want to.
Okay.
That was Herring State 513 Southern 2nd 122 from the Florida Supreme Court in 1987. Got it. I got a copy here.
Yes, and if I would,
And I will note I had a copy because counsel sent this citation. Well, I think she sent that version. I printed my own from Westlaw, but she sent it to my JA with a copy, what appears to be a copy to Mr. Basabe, and I think it appears counsel handed him a paper copy of that earlier, but again, the court was made aware of this case, so I just printed my own copy. All right.
and what I would argue, and again, not to in any way invoke the ire of the court, but on the third page of the bottom paragraph, and this is why we're asking the court to reconsider cases involving sexual battery committed within the familiar context present special problems. And it goes on, credibility becomes the focal issue. In such cases, some courts have in effect relaxed the strict standard normally applicable to similar fact evidence. These courts have allowed evidence of a parent's sexual battery on another family member as relevant to modus operandi, scheme, plan, or design, even though the distinction between sexual design and sexual disposition is often tenuous. We find the better approach treats similar fact evidence as simply relevant to corroborate the victim's testimony and recognizes that in such cases, the evidence probative value outweighs the prejudicial effect. So we would ask that the court revisit that. With that in mind, we would like to make the proffer.
Understood. Before we get to the proffer, didn't Herring actually affirm the trial court's keeping that out? And wasn't there subsequent legislation that resulted in 404 now to be talking about criminal cases? Herring was a criminal case. This is a civil matter.
Correct. We're offering it for the proposition that this goes to modus operandi, scheme, and also corroborating these victims' testimony.
Okay, understood. All right.
That's all.
All right. We'll go ahead and have the proffer of the witness.
Well, I can't object to that.
There's nothing to address until we hear the proffer from the witness. I haven't allowed anything.
What we could do, so I don't want to wait. I can finish Mr. Basabe's direct, staying away from that question for now, and then proffer the witness.
Okay. Again, he gets to cross himself, so to speak, but whatever. Again, that would be in a narrative form, but that's fine. We can
be very quick. I just don't want to waste the jury's and the court's time, and I know you
okay.
Very mindful.
Okay. Yeah. All right.
Would you rather bring the jury? I mean, he could be here. Just got to come up.
Again, it's 107 now. We're moving forward. So however the parties want to try their case, we'll move forward.
10 minutes.
Say it again.
10 minutes. If the court would entertain 10 minutes for the proffer.
For the proffer, that's fine. Let's bring him in.
No, he'll be here in 10 minutes. I'm sorry.
What's happening? I don't know.
Mr. Basabe?
I asked just what's happening. I don't understand.
They're going to voir dire the witness. It's a proffer of the witness's testimony outside the presence of the jury, so the court can make a ruling on their motion to reconsider the court's previous order that TS and questions related to that are off limits.
Who is the witness?
Say again?
Who is the witness?
That whoever TS is, they're about to call this person to the stand. We're about to find out.
Your Honor, we would ask that there would be no cameras in the room and that the courtroom...
Yeah, hold on. Let me check it.
Your Honor, I had asked for no cameras in the room for the trial as well.
Hold on.
We do have a...
And say again?
I was going to say, Your Honor, we do have a non-party trial witness emerge at most for a protective order.
All right. Let me see what you got.
Yes, sir.
Yeah, I'm already here. You like it?
We're not doing this now. I'll have to take that matter under advisement. Let's move on.
Sir,
Because I need to know under what statute would I prevent, are you asking to close the courtroom or just disallow cameras? Or then this motion asks for sealing of any records? We're talking, so.
I think we could do it very quickly. We do not want his image or his name, and that would be enough.
I understand that, and generically speaking, I agree with that. But the issue becomes under what statute is that allowed? Are we talking 918.16?
Your Honor, I believe it's Florida Statute 794.026. This person is a sexual battery victim. He has reported that he was sexually battered.
Right, I get that.
And Marcy's Law.
Marcy's Law. What about Marcy's Law? Can you cite a statute, just the generic Marcy's Law? I think the Supreme Court has not necessarily found that to be self-executing, or we don't know of that. I'm familiar with 918.16 that child sexual abuse victims, the court can clear the courtroom, but those are under the age of 16 or somebody has an intellectual disability. I understand that. So I'm just looking for, so again, that's why I'm punting this. And I will tell you, the media may want to file their own motion to say no. They may agree to it. I have no idea. That's why we're going to push that one down the road to the extent that you want to exclude the media from the courtroom. So,
Your Honor, if I may comment on that, I've spoken to this victim. He is not really concerned about the media. He trusts the media. They understand that he's a sexual battery victim. He gave an interview to the Miami Herald back in October 24. Your Honor has seen that news article. They used a pseudonym for him at that time. This person is concerned both with Mr. Basabe attacking him in the media, as he has done with our clients. And
then again, we're going to handle this later. We're going to move on. I got jurors in the box. This is much more in detail than this is much more in depth than we just want a quick pro forma motion. So we'll have to deal with that issue at a separate time. It's different bringing somebody in for a 10-minute proffer. It's a whole different ballgame, trying to restrict access to a public trial under the Sixth Amendment and curtail somebody's First Amendment rights. I understand as a generic proposition. I understand the import of it. I just want to make sure this is done right.
I think we do have a gentleman's agreement.
Me, I'm okay with it, but I've just been instructed.
Well, again, we'll take this up at another time. I'm ready to keep moving, folks.
They will listen to the testimony, but will not disclose the name or the image.
Okay. Well, again, that doesn't cover everything in this motion for protective order.
We're going to kick it down. We could do the proffer in the essence of time and then decide what to do with it. But I do believe that they will honor and not disclose the name or the image.
Okay.
And we can then.
Okay. If you want to proceed, all right, that's fine.
Thank you.
Let's bring in the witness. I'll remind the parties as we wait for the witness, this is not a discovery deposition. This is a very brief voir dire as it relates to the motion to reconsider.
Or should he continue to use the name since it's a proffer, the initials TS?
The TS is fine.
Yes, sir. Thank you, sir.
Obviously, if the court does reconsider and change its ruling, then the actual name will be appropriate. But at this point, TS is fine.
Yes, sir. Thank you, sir.
2 more minutes and we're going to continue on with the witness that was on the witness stand. We've got members of this community that have given them their valuable time and they're sitting in the box back there not hearing evidence.
May I ask a question while we're waiting?
Sure.
I'm just making sure I understood. Is the person who's coming in going to be only identifying themselves as TS?
At this point, yes.
My objection remains because the list identified only TS, and I had no meaningful notice of who this person was, no opportunity to investigate, no ability to determine if it's even the same individual as that placeholder name. The plaintiff should not be permitted to cure an inadequate witness disclosure after the court has already ruled on the motion in limine.
Okay.
State that for the record.
Understood. You would please raise your right hand. You swear or affirm the testimony you give in the case now in hearing should be the truth, the whole truth, and nothing but the truth.
I do.
All right, you may be seated. And for purposes of this hearing, are you the individual identified as TS, Tango Sierra?
Yes.
All right. With that, counsel, you may proceed with your voir dire.
We are here for you to give a proffer of what your testimony would be. So what I'd like to ask is, do you know the defendant?
Yes.
How do you know the defendant?
He drugged me and raped me.
Okay. Can you please tell the court about the event that occurred? We can start with, had you known him prior to that night?
No.
Were you invited to an after party?
Yes.
Did you attend?
Yes.
When you got there, was there an actual after party?
No, not really.
Pardon?
No.
Okay. I'd like you to please tell the court when you arrived what happened.
I arrived, drove my own car, and there was no parking for my car at this condo in Malibu. So I parked down the street, and I had invited my girlfriend at the time. She was with me, but she drove in a separate car. I went to this condo, was invited by Fabian to the hot tub while we were waiting for others to arrive. I didn't have any shorts, but he said we can all go in our underwear. I was an athlete, was pretty used to that kind of stuff, so I got in the hot tub. He offered to make me a drink, and he gave me a red Solo cup, which ostensibly was a screwdriver. It was supposed to be vodka and orange juice.
Did you take a sip?
Yes.
Can you tell the court what, if anything, you noticed?
Well, the drink tasted pretty funny. Thought it was maybe bad orange juice, so only had a couple of sips. And pretty shortly after that, I heard something to my left. I thought it maybe was my girlfriend at the time arriving. I looked over, but it took me a while for my eyes to catch up. And that's when I started to feel really strange.
Let me ask you, before you began to feel anything, had Mr. Basabe approached you in the hot tub?
Yeah, while I was sitting in the hot tub waiting for other people to arrive, including my girlfriend, he was to my right, and he scooted over to his left and put his hand on my right thigh. It was an advance, one that I was not comfortable with. But I said, hey man, I don't really roll like that. You're cool and all, but I'm not interested. He backed off a little bit, and we had a short conversation. And then that's when I started to feel a little bit strange.
All right. After you noticed you were feeling strange, please tell the court what happened next.
I started to feel real hot. Obviously, I'm in a hot tub, so I figured I probably should get out. Started to get real sweaty, and I looked around again, and it took me a while to get my eyes to catch up. That's when I knew I needed to get out. I had some alarm bells, red flags. I tried to get out of the hot tub. I pulled myself up and out. I took a few steps. My balance was way off. I liken it to on the dashboard of an aircraft. You have your horizon bubble that always kind of tells you which way flat is, and everything was leaning to the left. I took a few steps to the left and fell over onto my face. It was concrete, and it was a pool deck. Scratched and scraped my face. That's when I knew something was really wrong. I felt really nauseous and very strange. And in my head, I told myself, hey man, you got to get yourself together. Something is weird here. You got to get up and get out of here. So put my arms underneath me. I pushed myself up, got my legs underneath me, and took a few more steps and fell over towards my left again into some bushes. Scratched myself up a little bit, and then I was kind of on my side. And that's when I got really, really sick.
Can you tell the court what you mean when you say really sick?
It's ugly, but my stomach had really sharp pains, and I started having violent diarrhea and vomiting at the same time. And I was retching and kind of curling up in a fetal position. And my stomach kept compressing, and I was continually vomiting and having diarrhea.
And what happened next?
Kind of blacked out and came to on the doormat of the front door of this condo. And Fabian was telling me that it was a mess and he was going to help me get cleaned up. I kind of blacked out again. I came to and I was in a shower. I had no clothes on, and Fabian was standing over me and spraying me with the wand in the shower, washing me off all this filth. And I kind of blacked out again.
Right? What happened? Did you come to again?
Yes, I came to. I was on a couch, kind of lying down. I had no clothes on, and Fabian's mouth was on my penis.
All right. What, if anything, were you thinking and doing?
Well, I realized I was being raped, and I tried to get my body to fight back. I wanted to punch him. It was very clear in my mind, but everything in my body was moving very slow. My mind wanted to swing and punch him, and my arms weren't really working. My body wasn't really working. I was able to say no and stop, and I was able to kind of rotate my body to my left, on my left side, to get him off of me.
What happened next?
Fabian was right behind me in kind of like a spooning position. I started to feel some poking, my lower back, my buttocks, my thighs. And at that moment, I was becoming really frightened internally because I couldn't fight back. I felt his leg on my thigh, trying to move my leg up and kind of out of the way, and I felt more poking in my rectum, and I had to muster up whatever energy I could. I did not want that to be a reality in my life. Did not want to be a rape victim. And I was able to grab with my right hand a blanket that was on the couch right next to me. And I rolled it up and over my body, and I rolled again and off the couch. I rolled myself into kind of a burrito covering my body with the blanket.
What's the next thing you recall?
I blacked out after that, and I woke up many hours later. I was on the floor, and the sun was shining through the window. It was really hot. I was very hot in this blanket. I was sweating, and I had an incredible pounding headache. Every time my heart beat, my pulse would pound in my temple like there was a hammer beating in my head. And I felt awful. I felt really nauseous, and I was trying to figure out where I was, what had happened to me, and how to get the hell out of there.
Were you nude?
I had no clothes on.
All right. What happened next?
I needed to find my clothes and my phone and car keys. My keys and phone were in my jeans. My clothes were kind of nearby. Put my clothes on. I had to figure out how to get out of this house. I didn't know whose house it was. And basically quietly tried to exit, and came across Fabian and his friend, who was either renting or owned the condo. He was a friend of his from Pepperdine. He's from the Middle East. I remember that because I had spoken with him, and I was not excited to see them. I wanted to get out, but they were basically between me and the door. Fabian said, "Hey man, how you feeling? You had a rough night? You drank a lot. And I just wanted to get out of there. I didn't know where my car was. I'd asked him where it was, and he had offered to take me to the car. He said that I really should drink some water and a healthy juice. I didn't really know how to react. It's kind of like being in the Twilight Zone. I just wanted to get out of there, but I didn't want to make much of a scene. I still didn't know where my car was, so we went and got a juice. It was not actually a juice, but a wheatgrass shot, he suggested. It was a strange thing to drink. It's a little, very green shot of pressed grass and then a water. He insisted I drink that. I felt really nauseous. I got to my car, started driving down the 101. This is in Hollywood, basically through Hollywood to downtown. From Malibu, I had to pull over on the 101 and vomit. I remember it clearly because it was neon green. I was able to charge my phone, which had died. I had a bunch of missed calls, one from a couple from my sister and a couple from my girlfriend. I called my sister. I'd worked with her at the time. I told her that I couldn't make it in, and she knew immediately something was wrong. I told her what had happened, and she said, "Oh, my God, okay, well, you go home, we'll come get you." And I had to call out of work, and I eventually quit that job. I told my boss what had happened, and I told him I needed some time, and then I ended up just quitting that job and moving out of LA. I didn't want to be there anymore.
Your Honor, may I ask a question of the court?
Yes, sir. Go ahead.
Is this being streamed live? I'm getting messages from.
I have no idea, sir.
Is it not against the court order to be streamed live?
Next question.
Did you ever see him again?
I did. About 5 years later, I was in New York City, and I was walking out of a building, and he was walking in. And I'd always wondered what I would do if I ever saw him again. I tried to put it out of my mind, but it's not something you can easily forget. He was walking into the building with his wife, I guess, at the time. And my adrenaline immediately pulsed through my veins. I was shaky. I didn't know if I was going to punch him, or I didn't know what I was going to do. And I got very upset. I'm not proud of this, but immediately seeing me, he said, "Oh, hey man, how are you? It's been a while. How you been?" And I didn't know how to react to that because he was acting cool, like we were buddies. Not friends with this man who raped me. I've always wondered what I was going to do, and again, I'm not proud of it, but I asked his wife if she knew that he had raped me. I asked if she knew that he was a rapist. I asked if she knew he was a gay man.
All right, hold on. Counsel, where are we going with this? I think
I think we're wrapping it up.
we're done
Yes.
with that.
Great.
Any additional questions on direct?
Your Honor, I don't know that it would be important, but perhaps what it did to his life afterwards, but he is not a damaged witness. This is going
Well,
and so I'm inclined
for
to.
purposes of a 404 analysis, that's not relevant to this court. Understand it's relevant to him and his life, but it's
Yes.
for legal purposes, it's not relevant to the motion to reconsider the order not allowing his testimony.
I agree. Thank you, Your Honor.
All right, limited cross as it relates directly to this direct examination and the motion to reconsider. Again, this is not a discovery deposition.
Yes, Your Honor. I don't know if you can answer this, but will you state your full name?
No.
No, I've already ruled on that.
Have you ever worked for me?
No.
Were you ever my legislative aide?
No.
Were you ever employed by the Florida House in my office?
No.
When did you first meet me again? What was the date?
2003 in the fall or winter, early winter.
And do you remember the approximate dates of any other times you would have met me?
It was late 2008 or early 2009.
Do you know Nick Frevola personally?
No, I've never met Nick.
Do you know Jacob Cutbirth personally?
No, this is the first time I've seen these gentlemen.
So you haven't discussed this lawsuit with either of them?
No.
Have you discussed it with anyone else besides the attorneys at the plaintiff's table?
No.
Have you spoken with plaintiff's counsel about your testimony?
Yes.
Were you present at the Southern Group on January 3rd, 2023?
No, I don't know what that is.
Did you witness any interaction between me and Nick Frevola that night? Oh, you weren't there. Sorry. Everything you intend to testify about involves events completely separate from the allegations in this lawsuit, correct?
Well, that's up to opinion, but it shows that you have a
We're
pattern.
not going to go into legal determinations. Let's stick to facts. I need to know the facts to decide whether or not he gets to testify, not the legal conclusions. I'll have the parties argue that, and the court will make a legal ruling. All right, next question.
You have no first-hand knowledge to the events giving rise to this specific lawsuit, do you?
Sorry?
You have no first-hand knowledge of the events giving rise to this specific lawsuit, do you?
What do you mean by first-hand knowledge?
These three people have made specific complaints. Do you have first-hand knowledge of witnessing their allegations?
Are you asking me if I witnessed the allegations?
Of these three, of the two people, or of the plaintiffs here?
Okay, first-hand knowledge meaning you're asking if I was present when these things happened?
Do you have, I believe that's what it means. Did you see or were you witness to personally to any of their specific allegations?
No.
You said you don't know them, so no. Okay. Your Honor, this witness has no first-hand knowledge.
No, we'll argue in a second. Let's finish the voir dire of the witness.
Yeah, sorry.
All right, any redirect?
I'm sorry. Oh, no, never mind. That's right.
Have you been in any way paid to come here?
No.
Thank you.
No, not at all.
All right, the witness may step down.
Your Honor, where do you want me to go?
The council will have you, they'll show you where to go. Somehow, proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, and is not solely to prove bad character or propensity. So that's step one. And if they clear step one, we'll talk about step two, which is 403, whether the probative value is substantially outweighed by the danger of unfair prejudice or confusion, whether this becomes a trial within a trial. But you may proceed.
It's wrong. 442 expressly prohibits admitting similar fact evidence when it's offered solely to prove bad character or propensity. Plaintiffs are attempting to introduce unrelated witness to argue that because they allege misconduct occurred on another occasion, the jury should conclude that I acted in conformity with that alleged character here. And that's precisely what 404 prohibits. Furthermore, the witness has no first-hand knowledge of the events involving...
And we talked about that. I don't need you to keep regurgitating the argument. I've got that part.
If the plaintiffs are characterizing this as similar fact evidence, they have not identified any permissible purpose under 404-2A, such as motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake. Their only apparent purpose is propensity, which the rule expressly forbids.
All right, anything else?
You say I also talk about 403, that's next.
Yeah, anything else at 404 now? How about 403 if you wish to address 403?
Even if the court found any minimal relevance, any probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, and creating a trial within a trial over unrelated allegations. Accordingly, the testimony should remain excluded under these two 404A, 2A, and 403. One additional point, Your Honor. The allegations involving this TS character are entirely separate incidents involving different person at a different time and not part of the events alleged by Frevola or Copper.
I know you keep talking about that. I'm done talking about, I get it. It's not the same event. I got it. We're talking 404. 404 specifically is that it's not the same event. I got it.
Seriously.
Anything else?
Thank you.
Any final words from the plaintiff?
I think that the credibility and a central issue is this case largely turns on intoxicants. I'm sorry, I'm reading notes that I had in here. It's substantially the same method and the conduct that has been described within this case. And we do think that it is relevant to prove a material fact at issue. Other sexual misconduct, inappropriate touching, the similarities, I think, go to show that there is a lack of motive. This is intentional. There's not a lack of mistake. And again, it goes to corroborating the stories of the plaintiffs and their testimony. Their credibility has been put at issue.
All right. Before the court is the plaintiff's motion to reconsider the court's earlier ruling regarding TS. The court's got to make a two-step approach on this. First is 404A2 or 2A. The court has heard from witness TS that has talked about back in 2003 meeting the defendant, being invited to an after party, that it was not a real after party, that he was invited into a hot tub where, based on not having swimming gear, he was told he could and decided to wear underwear. He was then offered a drink in a red Solo cup. He described a funny taste after a couple of sips and physical manifestations of some sort of ill effects. Those ill effects were to include nausea and intestinal distress. He mentioned nausea and diarrhea, feeling strange, feeling sick, having lost balance, falling over on his face, having blacked out, with the court familiar with blackout, having experienced fragmentary blackouts during periods, and not an en blanc blackout, but a fragmentary blackout, that the defendant was helping him to clean up in the shower, spraying him. He awoke then with the defendant's mouth on his penis, and he described what he felt was a sexual assault, that his body was unable to move in normal ways, describing it as slowly, describing that he denied the defendant telling him no and stop, but that he was unable to fight back, except eventually being able to roll over with a blanket, having woke up with a headache and his pulse racing, leaving the house, and then ultimately that morning, the defendant saying, "It looks like you had a rough night. You should drink some water, have some juice." And then he saw him 5 years later in New York City and acted as if nothing had occurred. The court will note the allegations in this case and these plaintiffs. The issue is this is not Mr. Diaz's allegations. The court, had this been Mr. Diaz's allegations, I would find under 404 2A that this does meet the appropriate standard of intent, preparation, and plan, motive, and opportunity. However, that Mr. Diaz's events, although related to these plaintiffs, are somewhat tangential to the plaintiff in this case. Accordingly, under 404 2A, I find this evidence to be inadmissible. Further, under 403, because it is marginally relevant and it goes to a tangential issue, I find the danger of confusion of the issues in this case to substantially outweigh the probative value of this evidence. The court makes no findings as to whether this happened or did not happen, as that is not appropriate for the court at this matter. The court takes the allegations at face value for purposes of this motion only, as that is what the court is charged to do. Accordingly, The motion to reconsider is granted because I heard testimony, but the court reaffirms its order denying the plaintiff the ability to call TS in this case. So with that, we'll take a 5-minute recess. We'll come back and we'll continue with Mr. Basabe on the witness stand. With that, court is in recess for 5 minutes.
All right, court is back in session.
Everyone, please be seated. With that, Mr. Basabe, if you'll go ahead and take the witness stand, we'll bring in the jury and proceed.
May I make one statement, Your Honor?
Okay, go ahead. What?
One exists. The court. I object to any line of questioning that opens the door to inadmissible evidence. To your prior motion, and the line of questions by virtue of the attorney asking questions like this, it's a lot.
Hold on. Nope. All right, maybe seated. The objection is overruled. All right, afternoon, ladies and gentlemen. With that, you may continue your examination, Ms. Fiker.
All right. When we had broken, we were talking about that you were offended that you had been accused of slapping people, sexual harassment. Is that correct?
If I said I was concerned, was the word, those are the word I said was my initial reaction. And then I'm reading through here to see if you're trying to remind me of my sentiment of that exact moment for that exact day. Give me a moment, please.
To a special type. Is that concern? That seems offended. You tell me.
There's grave concern that people can just walk around saying anything about anyone and trying to get away with it, right? There's grave concern that people try people in social opinion and media instead of due process. I mean, there's grave concern. Concern is my first response to this. I'm very concerned.
Very conservative?
Concerned.
Oh, concerned. My bad.
Would you like me to explain my politics?
Scrupulous, entitled, self-involved, ungrateful, line scum. Is it still your position that you were merely concerned and not outraged?
And asked and answered.
Non-responsive.
Overruled. You may answer the question.
I am, first and foremost, very concerned. Very concerned. Also concerned at who put them up to this? I have lots of questions. There are grave concerns.
Your case in chief, you'll have that opportunity. All right. If I heard you correctly, you are concerned that people can just make wild accusations. Did I hear that correctly?
I'm concerned at the lack of due process.
Okay. Was this the first time anyone had ever accused you of being or touching them inappropriately? Just
Objection, Your Honor. I believe
or inappropriateness.
Overruled. You may answer the question.
To these specific allegations, this is the first that these people have made these allegations. Repeat the question if you like.
Oh, okay. And I'm not talking about the things we had at the sidebar. Is this the first time that anyone has made allegations that you sexually harassed them?
There's a lot of gossip. I'll chalk it up to gossip.
All right. I'll take that as a no.
Please don't answer for me.
The jury's here. Has it ever been accused before that you had sexually harassed someone?
I'm not understanding how you're presenting. For me, accused is by a state prosecutor of a crime. I mean, these are crimes you're talking about. And I have never been accused by any prosecutor.
Non-responsive. Let's answer the question she's asking.
Just like these people have been, and by these people, I specifically mean Mr. Nick Frevola and Mr. Jacob Proffer. Has anyone ever accused you of sexually harassing them before?
I want to be very specific because you have a friend of theirs that you're trying to get as a witness.
Next question, counsel.
I'm moving on. Yeah. Okay. You said here, let others learn and let this episode stand as a warning for those who plot harm. Is that a threat for people not to come after you, Mr. Basabe?
Objection, asked and answered about this.
Overruled.
So, this last statement, in its full context, was meant to say, let it learn from this episode of people saying something, having it heavily investigated and disproven, let it be a lesson for those who want to just plot harm for political purpose or any other purpose.
You wrote that.
Well, this is my opinion. This is my opinion document that you've provided.
We'll let the good jury decide. You are insinuating, however, that these people who reported you have done something wrong, correct? By this tweet. You believe they did something wrong by reporting you for misconduct, inappropriate touching, sexual harassment.
I'm sorry. Are you saying that they did report this?
No. Am I saying? Let me rephrase the question. I'm not sure where that came from. You are, in this tweet, calling them a conning, scheming mother and son duo who appear to be making suing profession. They have reported a history of lawsuits. Anybody they think can and will pay. What a shame. What a waste of a perfectly good opportunity to make something of yourself, your life, on and on and on. You're insinuating they did something wrong by reporting what you did to them.
I think you're taking that out of context. I am expressing my opinion on people who reported something and couldn't back it up with any evidence whatsoever, and it was
Non-responsive, Your Honor.
Same.
Do you believe they did something wrong with reporting you?
May I ask who it is that you're claiming that they reported me to?
According to the testimony, Human Resources.
I do not think that what they did by reporting something, if they believed it were true or not, or if they, for whatever their reasons, if anyone has, I'm sorry, restate the question.
Do you believe that my clients were wrong in reporting your misconduct to Human Resources?
Now I'm understanding what you're saying. You're trying to ask me if somehow I did misconduct and then they reported it and that was wrong. So I don't agree. I did not do this.
Wasn't my
misconduct.
question, sir.
So what I'm disappointed in here, you interrupted.
Hold on. We're talking over one another. I'm going to short circuit this. All right. Sir, is it your belief that they committed misconduct by reporting to Human Resources an allegation of misconduct against you?
So it's my position that the motive behind why they reported is wrong.
Okay.
Motive of why they did it.
All right.
It wasn't true.
All right. Now, you don't mention anybody other than the mother-con duo, correct? It's your aide mentioned at the bottom, specifically the name Frevola, and a mother-son con duo, right? Not the Democrats, not the Libertarians, not Antifa, not some great conspiracy who's out to get Mr. Basabe, a mother-son duo, correct?
So you're referencing this one specific opinion, but you're on my Twitter page. There's many mention of this. And would you like me to provide mentions?
I'd like you to answer my question.
So what is your question?
The motive behind what they did was wrong. So according to this, it's just a mother-son con duo, right? Show me any place in here where it's something other than a mother-son and Frevola.
So in this specific opinion statement that I made, what I thought was wrong was that they reported something to the media before anyone else. Then it ignited can I answer the rest of the question? It ignited the two massive investigations that took up 3 years of my life, which interviewed anyone and everyone that they tried to loop in, of which not a single person could corroborate anything.
You heard any testimony that they're the ones who've been to the media? In fact, if my memory serves correctly, the only testimony we've heard is the media came to them.
So I have heard in the depositions that
you didn't attend them, according to you.
Doesn't mean I didn't read them.
You told me earlier you didn't have them. Are you saying you have them now?
Excuse me. I told you specifically I couldn't get 2 of them. And I asked you for them and you refused to give them to me. You gave me.
We're not doing this in front of the jury. We're going to next question.
Next question.
Okay.
But you wrote this, you published this. No question about it, correct?
This is one of my many opinions on my personal opinion.
I'm talking about just this one, sir. You wrote this, you published.
I reference this is one of the many personal opinions that I've put on my Twitter.
Can I just get a responsive answer?
I can't help you.
The objection non-response is sustained. Did you write that post?
I did, Your Honor.
Thank you. Next question.
Yeah, you know how many people have seen that post?
I'm a public figure. I can imagine a lot.
Chance to go back here on 6/29 of 23, there were 19,000 views. That was years ago, 3 years ago. And you did, well, let me ask you this. Did you have a chance on the break to go and look and see if you've removed it?
No, but you didn't ask me to.
I did not ask you to. That is correct. So as we sit here today, you said you don't remove things you put up. Is there any reason for us to think that this doesn't still exist today?
I really haven't checked, but there's no reason to believe it is. I really don't even manage my social media.
Thank you. Do you have any plan of taking it down?
Are you asking if the plaintiffs are asking me because somehow they think it's affected their lives? I'm a very decent person, and I'll happily consider it.
This lawsuit has been going on for years. You're willing to do it now?
They're thriving, and one of them was always a loser.
Which one? Which one was the loser?
Well, I didn't single one out yet, but it seems one just offered himself up.
Which one? Who's the loser?
One who, in all the years of service, could not get any substantial job that give him the benefits or anything that his career goals at. The one that could not get any job offer again for anyone he worked to. He mysteriously found other opportunities, but was never offered the job back.
Okay.
Ever.
Would that be Mr. Nick Frevola?
Yes.
He's a loser.
In my opinion, yes.
Okay. You know, I think that's a great place to end. I don't have any more questions or anything.
All right. Cross-examination.
Myself, yes.
Hold on. All right, with that cross-examination, ladies and gentlemen, this is a little different. He doesn't have to ask himself questions. He's going to give a narrative that's responsive to the direct examination. He'll be allowed to just speak to you like a normal person, as long as it's, again, subject to objection. But he's not going to have to ask himself questions and do something weird like that. So he's going to be given the opportunity to speak. And remember, I told you, when he is on this stand, what he says is evidence and may be considered by you. What he says at the podium is, or at his table is not. So again, you may consider the statements of the defendant, like when Ms. Viker was asking him questions, as evidence. Again, as he testifies up here in a narrative form, you may consider that, or you should consider that as evidence. The weight you put on him and any other witness is ultimately going to be up to you. With that, Mr. Basabe, you may proceed, sir.
I can't speak to their motivations. I just want you all to know that I cooperated with all investigations, representing myself.
Objection, Your Honor. Could we sidebar just very, very briefly?
Yep, you may. All right, sir, you may proceed.
She asked me about my marital status, and then tried to put a picture as if somehow that's supposed to have some sort of shock value that I may be stepping out of my marriage. And I want you all to know that I am honest with everyone in my relationship. And this photo, if you look at the bottom, it's done by Patrick McMullen. If you don't know who that is, he's a very famous photographer, and he's known for doing something called the Kiss Book. And he asks people to kiss, and because the more love in the world, the better. And there's rock stars, there's artists, there's socials, there's everybody in this book. There's several books of them. They've had anniversaries of these books. I was trying to go through some of them. I found the most amazing one. If I may show this picture, it's of me and my friend Rose McGowan.
Then, Your Honor.
No, well, let's not just be flipping our phone around and showing it to people.
I haven't seen what. Would you like to see this before anything?
So don't know what this has to do with.
I just picture. Oops.
Not going to argue in front of the jury. Show her what you would like to show this.
So now I'm show you on.
No, don't. Plaintiff, Ms. Viker.
Sorry.
May I show this?
Any objection to him showing whatever there's something located on his phone?
It's a kiss.
Okay. You may use a demonstrative. Go ahead.
Sorry, what does that mean? That machine? Or just show it? It's not relevant, really. It's just a picture.
Well, if it's not relevant, then why are we showing
No,
it?
I mean whether I use the machine.
Oh, okay. Yeah, you can show it to him.
If I'm wrong. And there's also of myself and my wife. There's a bunch of kissing pictures of my wedding party, which was attended by 500 something people in New York. Anyway, just put in context, in case there's anything that ever tries to act like somehow I'm not honest in my relationship. It is a private relationship. I don't offer it to them. I understand that there's a lot of inclusivity about my personal preferences, but no respect that I might be respecting other people's privacies in my limited answers to it. But I also think that everyone has the freedom to live any kind of life they want. But they also have the right to their privacy, especially when it comes to the other person that's in the relationship. Not everybody's at the same position in their life. Okay, move on.
Jane.
I've answered as truthfully as I can. I think what I should ask myself.
Or you can relive, either one.
I should also state that a person's sexual orientation, regardless of it, doesn't determine whether they committed misconduct. Only evidence does.
Objection.
That's it.
Sustain, outside, and argument. All right, next.
In the interest of saving time for the court, Your Honor, I'm glad you. The next step is.
Okay, redirect.
One question. Is it okay for gay men to sexually harass men who tell them they are straight?
I don't believe harassment of any kind is okay.
All right, you may step down, sir. Plaintiff, you may call your next witness.